Sometimes clients ask me whether it's actually necessary to have a third-party escrow agent in order to establish a source code escrow. Perhaps they want to avoid the expense of entering into a formal escrow relationship where it just seems to be too much trouble. Whatever the reasons, I often hear companies ask questions like, why can't I just promise to provide the source code in the event that a triggering event occurs? Or a licensee simply says, why can't I just hold on to the source code? I won't use it unless and until a triggering event occurs. When lawyers hear these suggestions, we tend to chuckle at them because the triggering events ordinarily occur in one of two situations. They occur at a time when there is some conflict or dispute between the parties, or when the licensor has become incapacitated in some way. So, for example, if there is a failure of the licensor to provide promised maintenance and support for software, and that's considered a triggering event, let's say, in a particular situation, a licensee would ask for the source code, and if the licensee would ask for it, and if the licensor had merely promised to provide that, the source code so that the licensee could support itself, we'd have to wonder whether there's any dispute about the failure or non-failure to provide promised support. Perhaps the licensee contends that support hasn't been quick enough, or that a fix to a problem in the code has not been adequate, and perhaps the licensor disagrees. In that situation, the licensor is ordinarily going to be reluctant to provide the source code to the licensee. If there is no dispute, of course, they can always provide the source code to the licensee. That can be done at any time when the parties mutually agree. Of course, they should put appropriate terms in place to protect the confidentiality of the code and to govern the usage rights that attach to them. But there ordinarily is a dispute, which is the reason why the licensee wants to have the code in the first place, or there's a circumstance where the licensor is unable to provide the promised code support and code maintenance. This might commonly occur when a licensor has entered bankruptcy or has wound up its business. In those situations of incapacity, such as bankruptcy, it will become impossible for the licensee to compel the licensor to provide the source code to the licensee. In the United States, under our bankruptcy law, if the company is subject to bankruptcy, its contracts, its contractual commitments may be placed on hold, as it were, and so the licensee could not, in a court, compel the licensor to hand over the source code at that time. That's why we need to have a third party available who is simply not a party to the dispute and is not incapacitated, but who has promised one or both of the parties that should an event occur, which the parties have agreed should be a release event, the third party at that point will simply, as a matter of performing services, provide a copy of the source code to the beneficiary in that instance. That third party is not subject to bankruptcy, let's say, and because it's not subject to bankruptcy, it is able to provide the code, or if it refuses to, since it's not subject to bankruptcy, the licensee could compel it to provide the code. It's not under that legal constraint. There's no dispute between the third-party agent and the beneficiary, and so we shouldn't expect there to be problems about getting access to the code from a dispute. And so it is simply the case that we should always have a third party having custody of the source code and acting in a contractual capacity to be the provider of the source code to the beneficiary should a release event occur.